Hi guys, hello. My name is Alina Shaltsova, New York immigration attorney. Today we're having our live. I'm going to share with you most interesting immigration news. And of course, as always, I will answer some of your guys' questions. So welcome, please join me. Don't forget to type up your questions. Let me know where you're watching from. I hope that everybody is okay. Today is Wednesday, May 29th, 2024. We will be discussing quite interesting developments in our immigration life, what's happening. I'm going to comment on some news with regard to what Biden's plans are. Of course, I don't know what his plans are. We're getting this information from the news sources. But nevertheless, you need to know that something is coming up with regard to our southern border and asylum system. We're also going to talk about Florida law that was blocked. Is it a good thing, a bad thing, and how important what the significance of the ruling is. And of course, as I said, I'm going to answer your guys' questions related to the United States immigration law. So thank you very much for joining. Hi, Shigal from Houston. Nice to see you. Don't forget to let me know where you're watching from. And let's start. Yes, type up your questions in the comments so I can go back to them after I'm done with my presentation, and I'll be able to help you out and answer some of the questions for free. So first of all, and I published a little video about this today already throughout my social media network. You know that it seems that the Biden administration is considering shutting down the southern border completely, at least for a while. Title 42, but I believe it's 212F section gives President authority to undertake certain executive measures in case of certain crisis. And it seems that the Biden administration is going to use just that authority to shut down the border. I'm sure many of our Republican friends and subscribers are going to be cheering and applauding this measure. I have to tell you that this has been in talks for a while, that the Biden administration is going to do this. They've been considering it. Recently, the DHS secretary stated that some asylum seekers are gaming the system. So it seems that the change is coming. Again, it's not going to be permanent. It's going to be something temporarily. How temporarily it's going to be, I do not know. And it seems that for this to be accomplished, Mexico has to be on the same page with the United States. And from the news sources that I reviewed, all those news sources cite that basically what's happening is that the United States is negotiating now with Mexico as to how to go about this plan. And what I think is going to happen is something similar to Remain in Mexico policy, where if you would like to ask for asylum in the United States, you would have to remain in Mexico until your case is being heard. And perhaps even something more drastic, where you have to request asylum from Mexico first, asylum in Mexico first, rather, and only if you don't receive asylum in Mexico, then you will be able to have a shot at asking the United States for asylum. Perhaps something like this. We're going to see exactly what's going to happen. For now, you need to know that already in place, there is an asylum ban. Thank you very much, Hassan, for the rose. By the way, thank you guys for liking and sharing this stream. Thank you for your stars. Thank you for the roses. Thank you for hearts, my TikTok followers. So you already need to know that already in place, if you entered the United States May 11th, 2023 through May 11th, 2025, which is in the future, but if you're going to enter the United States within this period of time, thank you, Hassan, very much, you need to know that prior to asylum officer considering your asylum claim or the judge considering your asylum claim, you will have to convince them that you had this exception, you meet the exception to the ban for asylum. Thank you, Hassan. I have like Tons of roses from you. Thank you very much. If they were real, I would be holding a huge, huge bouquet right now. So it's a very serious ban. Many are overlooking it, but some judges in courts, because I do appear in courts for my clients, I hear them instructing attorneys saying that before the individual hearing, if your client entered the United States without a visa, parole, or CBP-1 appointment, you must address the issue of this asylum ban in your brief, legal brief. Extremely important to know that. Why? Because if you don't address it and your client is asked questions and your client seems not to qualify for an exception to asylum ban that already exists, his or her asylum claim will be denied. You won't even be able to move on to the next step of considering asylum because you will not be able to pierce this initial wall for qualifications for asylum. This is in place already now. Now, and on top of that, the government tries to physically prevent people from entering the United States, it seems, by developing these new regulations. What's going to happen? We're going to find out soon, right? Right now we're only guessing. Next piece of information, Florida law. You know that Florida adopted certain law that is hostile towards immigrants in terms of criminal punishment is being introduced for those who work without authorization, who drive in Florida without authorization, who remain in Florida if they enter the United States without authorization, and so on and so forth. So part of this law was found to be unlawful, but only part that relates to driving an immigrant in Florida who entered the United States without inspection. At least part of the law was found to be unlawful, which is an important part, by the way, right? The United States does not have a super duper developed public transportation system. So most of the people who are in the United States rely on being able to drive or being able to be driven. Private cars, right? That's why private car industry is so developed here, because there is no system of public transportation that is as developed as in some countries in Europe, for example, where you don't have to own a car. You can get anywhere you want using public transportation. In the United States, public transportation is developed only in the largest cities, such as New York, for example, New York City, such as maybe San Francisco, such as Washington, D.C. But if you get out of the city centers and you are in smaller cities, there is no reliable public transportation system which is convenient, fast, and frequent enough for you to get by without a private car. So this part of the law was knocked down. It's gone. You also need to know that the US government is suing, the federal government is suing states for other states that adopted anti-immigrant laws. Very interesting situation is happening currently. And judging by this particular example of Florida law, we can predict that, at least in some cases, the federal government is going to win, right? So, as scary as those laws, local laws sound in Oklahoma, Florida, Texas, at least portions of those laws are going to be eliminated. We know that, but perhaps not the entire laws. So there is still danger that some states are going to enforce their own immigration laws, it seems. You need to know that if you reside in those states, currently the notorious states are Texas, Arizona, Oklahoma, and Florida. But the biggest change is not coming from this news. The biggest change is coming for those of you guys who are in immigration court system or were in immigration court system. If you had an order of removal against you, if you are going through the removal process. Why? A final rule on efficient docket management was published that is going into effect 60 days from now. That rule changes the way the judges are authorized to process applications for motion to reopen, administrative closure, termination of the proceedings. I'm still trying to digest the rule, but one thing that caught my attention was about cancellation of removal and motion to reopen. According to this rule, it says that the judge will be authorized to grant a motion for reopening of one's past removal order for the purposes of filing for cancellation of removal, but only if a person qualified for cancellation of removal at the time when the notice to appear was served. Not sure how it's going to reconcile with the law that says that if the notice to appear did not have time and place, time and date at the bottom of it, then that notice to appear was defective for the purposes of stop time rule for cancellation of removal. But this is an important remark in that rule, very important change. And practitioners who are representing clients before immigration courts, immigration judges, Board of Immigration Appeals as well, must get familiar with this rule. It's quite lengthy, so I'm still reading it, but you need to know that if you're going through the process of motion to reopen, if you already filed something or appeal, if that rule gets into effect at the time when your judge or Board of Immigration Appeals is going to make decision on your case, you may get a negative decision just because of this recent change in the law. So don't be upset with your attorney, okay? Lawyers struggle and can do just so much. We don't control the rules that are constantly changing. So this is my contribution into trying to get you informed with regard as to what's happening in the United States immigration system currently this week. And now, if you guys have your questions ready, I'll be happy to help you out and answer them. So let's see. Hi, Bella. Hi, Wahab. Hi, Igor. Is it possible to terminate proceedings while I-130 is pending? Sure. You will have to ask the prosecutor to agree to that first, I would think. You have to show that you have a pretty strong case and you are otherwise adjustable. And then if the prosecutor doesn't mind, then they will present a motion to dismiss before the immigration judge. Okay, that's how it works. Usually, in my experience, the prosecutor would like to see certain security documents or security-related concern documents, such as your military record, if you had any, such as records related to your entry, just to make sure that they're doing the right thing and you're not going to end up in removal proceedings a year later because your adjustment of status is denied because you actually were not adjustable. Okay. All right. Hi, Maximo. Hi, Dee. Can my son, I guess that makes $31,000 last year, be co-sponsor for my wife petition? Can he be a co-sponsor? I do not know, because not only salary is important. When we talk about I-864 affidavit of support, guys, we have to take into consideration not only how much money the person makes, but also who that person is responsible for, how many people. If your son is married, if he has a child or two, if he claims someone else is dependent on his paperwork or his taxes, that means that his income has to be higher than the minimum income for two members in a household, all right? But the way to check it, you calculate the person's household size, and then you check the income, W-2 income that they receive per year, and you check it using I-864P, as in Peter table, published by USCIS for current period, current year, fiscal year, and you'll see if compared to that person's household size, the person's income is sufficient to become a sponsor or joint sponsor for somebody else. All right, that's how it works. Hi, Ali Karam. Is there any update about the undocumented immigration plan? Not that I know of. I know that we are waiting for some executive orders that perhaps are going to be published in June. Some of them may be positive with regard to parole in place, for example, and I had several videos here about that. But so far, I do not have any specific dates, any specific plans, or any specific language that I can share with you with regard to those plans, okay? But as soon as there is reliable information, I will publish it and I'll comment on that too. Hi, Mahlet, have been on Renewal for 15 years. I've been married 10 years. Now I'm on third interview. Will I be detained? Detention policies depend on local office policies. When Trump administration was in charge, many people who had previous removal orders who would show up for their marriage-based interview would be detained. Currently, I've never heard of it, but there is always a possibility if you have an unexecuted order of removal that you may be detained. Hire an attorney to go with you for that interview. Prepare very well. What is your plan? If you have a removal order, you cannot adjust before USCIS unless you're an arriving alien. If you could, you probably wouldn't be asking me this question because you would be filing for your adjustment of status and you wouldn't be worrying about detention, right? But you need to have a plan. Are you planning on filing for the waivers, motion to reopen? You know, what's happening? So, you know, I think you're probably not going to be detained. Recently, within the past 4 years, I've never heard of such instances. But again, it depends on reasons for your previous removal. Work with an attorney, and I think you'll be fine. Okay? I think you'll be fine. Now I'm going to take some questions from my TikTok followers, my loyal TikTok followers. Thank you very much, guys, for your hearts, for your gifts. Let me see. Hi, Romero. How can I get an agent on the phone if I didn't receive I-751 notice number yet? Romero, first of all, I've noticed that if you filed your case recently within the past 2 months prior to April 1st, USCIS has processing delays for the cases and you will receive that receipt a little bit later, not within 30 days as we used to, but within, I would say, 60 to 90 days. Do not worry, you're going to receive it. But I teach everybody, guys, when you submit paperwork to USCIS, use personal check for the fees. If you do so, as soon as USCIS cashes that check, you can check with your bank. On the back side of the cash check, record of which are available through your online banking, there is that receipt number printed for your case. The back side of the cash check. How can you get an agent is a totally different story. I once had a conversation with a client who said, well, why don't you call for me to USCIS? I said, absolutely, but then you will have to pay us a lot of money. She said, why? I said, well, because, you know, it takes hours to get somebody on the phone. And the way the system is set up is only an attorney can get an agent on the phone. Then I can delegate the conversation to the paralegal with if I give them authorization. But I have to be on that phone, glued to that phone for several hours. And the client was like, oh, but then I have to do it myself and I will never reach them. It's tough, guys. It's not fair what's happening with USCIS customer service. To get the live agent, it takes forever. But also going back to your question, Romero, the problem is this. Even if you get the agent on the phone, you're not going to accomplish anything. They're not the ones who are in the mailing room of USCIS where you sent your documents. They will not be able to, you know, confirm for you that they got the package. You will still have to wait for the package either to be sent back to you, or you have to check those bank records to see if your check was cashed. Okay. Hi, Carter Lodge. Hi, if you take deal with the government, can you apply again for asylum? It depends on the deal, I think, that you took. Yes, I would say so. It depends on the deal that you took. If you got a dismissal for your case, Why did you do it? If you feel that you have an asylum case going on, which is a winnable case, sometimes people actually request dismissal and then they refile case with USCIS. But if previously you already filed case with USCIS and you were referred to court after the interview, and then instead of going through with the case in court, you decided to agree to dismissal of the case, most likely USCIS is going to issue a notice to appear and send you back to court afterwards. So just have a plan with your attorney and see if taking the deal is the best option for you. Hi, Khan. I sent documents for EAD renewal to USCIS in the last week of April and didn't get receipt yet. That's normal. Don't worry about it. It takes forever now to get the receipt. Thank you very much, Hassan. Hi, Sharmila. If you re-enter, is it possible for me to have a social and work permit if I have an approval of what? That the message got cut off. Hi, Alexa. Is there any reason why I have not heard from CJ if my priority date of 8/14 and they're already processing 2020? Is there any reason if you're not heard from CJ? Not sure what CJ stands for. The thing is this: when your priority gets current, it's on you to file for that adjustment of status. All right. So I'm not sure what's happening with your case, but guys, it's on you to start processing the case, not on the government. In fact, in many preference categories, if you do not act on a case for a year after priority date is current, they're just going to say that you were too slow and will terminate your case. Hi, Jake. I need a lawyer wife. Trust me, you should reconsider that. And I'm not single, no, I have a husband. Eagle. What is the next step once the embassy issues visa for parents? They have to travel to the United States, right? Absolutely. Travel to the United States within the validity of that visa, not to lose it. All right. Okay, what is the next step? All right, we have that. My case with USCIS was affirmative asylum, and still I'm not yet with appointment interview in court. All right, so you have affirmative asylum case and you're waiting for your affirmative asylum interview forever. Welcome to the party. Happens all the time. In fact, I had a video here sharing with you guys that apparently there are people who are waiting for their affirmative asylum interview for 10 years. Imagine that, 10 years in the United States, waiting for the affirmative asylum interview. Can you do something about that? If you want, you can. Number one, you can ask the government to expedite your interview if you have good reason for that. And number two, you can file a lawsuit against the government. Mandamus. Do you need to do that? Is it a good idea for you to do that? It depends on your particular case. I don't recommend everybody doing that. It would be a wrong recommendation. Not every case is suitable for this mandamus route, but some cases are suitable. But you also need to know that that's expensive. You're suing the government and that's expensive, okay? Because the government fights back. Hey, Jay, thank you very much. My TikTok followers, would you be able to share this stream and send me some hearts so we reach 1,000 hearts today? What about people, hi, God's plan. What about people in removal proceedings at the court legal married couple? If you are in removal proceedings and you're legally married to a US citizen, you can adjust status if you have lawful entry to the United States, either before the court or before USCIS if your proceedings are terminated. Unless you're an arriving alien, then you can file for your adjustment of status before USCIS. If you are legally married and your spouse is not a US citizen, then usually both of you will be in removal proceedings. If one of you is filing for some relief, let's say asylum, and wins, the other spouse receives status automatically. But not always. Let's say one of the spouses files for cancellation of removal. That's an individual relief. If you receive cancellation of removal, your spouse is not going to automatically receive cancellation of removal. All right. So if you have more details to your question, I'll be happy to answer it. Hi, man. How can I get a work visa as a Canadian citizen to work in the United States? See if you qualify for TN visa. Easy to receive relatively and specifically for Canadians. Let me answer some questions from my YouTube followers. All right. Hi, ProsperCom. What are the chances of having my case expedited based on urgent humanitarian reason? I do not know. Honestly, it depends on the reason. If it's a medically related reason, chances are very good, provided you have strong medical records to confirm that reason. Hi, Richard. I have been deported since 2004, over 20 years ago. Over 20 years have lapsed and my 10-year bar is over. Will I have any issue returning to the United States? My sister had petitioned for me in 2015. You may. It depends on the reason for your deportation, all right? If the deportation reason related to fraud, criminal activity, then you still, even though you served the bar, may have trouble coming or being admissible, because the 20 or 10-year bars that you received, that only relates to deportation itself. But why you were deported also matters. Okay, so consult with an attorney, show them your immigration case files, and they will be able to answer this question better. If you would like to consult, guys, with me individually, please call my office 917-885-2261 or book your appointment online using my website, shoutsober.com, and we're going to go over your case and see what routes can be taken to improve your immigration situation. Hi, Solo Dude. I'm in California. I-751 processing time, please. I submitted in April 2024. 4 years sometimes it takes. I don't want to disappoint you, but it may take a very long time. I do not know the grounds for your I-751. If you are solo and submitted a waiver, usually such a case takes longer. If you guys had a joint filing, such a case, and you had a strong case, within a year, you should get your permanent green card, usually. Hi, Alex Silva. Hello, I'm a US resident. Can my girlfriend get her residence through me? I guess it depends where your girlfriend is, what status she has now, and if you're going to make her your wife, okay? If you are a US resident and you marry your girlfriend and she has lawful immigrant status in the United States and will have it for the next 4 years, then yes. If you're going to become a US citizen and marry your girlfriend and she had a legal entry but not necessarily maintained her lawful status in the United States throughout her stay, then the answer is also going to be yes. If your girlfriend is without lawful status in the United States or doesn't have legal entry, no lawful status, and you're just a legal resident in the United States, even if you marry her, she's not going to be able to adjust her status in the United States, all right? So some planning needs to be done here. You guys need to see what is a good timing for everything, what would be your prospect of getting the citizenship, and then perhaps, depending on her manner of entry and her status, she will be able to get that green card. All right, let me take the last question for today. Hi, Arturo. My wife pulled out my petition and we're still in divorce process. I'm seeking VAWA due to her actions. We've been married for 10 years. She kept all money and assets. Listen, I'm sorry to hear that. It seems that there is a lot of trauma going on. And I'm sorry that you're going through such a hard time, especially after 10 years of relationship. You need to know that if a person simply stops the petitioning process for you, if they withdraw their I-130 for you, that by itself, without more, is not grounds for VAWA. But if it is, such an action is coupled with threats of deporting you, threats of stopping the status, intentional infliction of that emotional distress, using you financially, you mentioned something like that, sometimes even physical abuse. Women can be physically abusive as well. There is this misconception sometimes that only women can be beaten up in the marriage. No, I met a lot of guys who get beaten up in the marriage too. And it's terrible. It's terrible. Nobody should go through physical violence or threats of physical violence or any violence at all. Then sure, even if your spouse pulls out their petition, you still may proceed on your own through VAWA, and the VAWA process is actually confidential, and your spouse is not going to know about that, and USCIS cannot even question them about that. So that's very important, okay? That's very important, and you may fix your status without them. Hi, Moshan. What time does your show come on, please? Oh, okay. All right, so my shows usually come on between 5:30 and 7:30 p.m. on Tuesdays and Fridays. Today is an exception. I was tired last night. I had a very busy day and couldn't do it. So it's a good reason for you to be on and checking my page regularly. I have, when I have a show, I have it on TikTok, YouTube, and Facebook. You can use any of the platforms that you like. I'll be very happy to help you guys out. But yes, usually it's Tuesdays and Fridays. Today is an exception, but here we go. Look, we have so many people, over hundreds of people between all the platforms watching live, which is, I think, is great. Now, I promised the last question for YouTube. Now I'm going to have the last question for TikTok. Hi, Hassan. If I take TPS and I also am working inside, I pay tax also, my asylum is going to affect TPS. TPS and asylum are two separate things, guys, not affected. But if you are called for asylum interview and you are found not to meet asylum standards, qualifications at the interview, and at the same time you already have TPS, what's going to happen is that USCIS is not going to place you in removal proceedings. That's the big difference and the only difference. So if you have TPS and you have asylum, you're waiting for asylum interview, do not withdraw it. Give yourself a chance. What if you do win asylum? Asylum leads to a green card. TPS by itself does not. But when you have TPS, the biggest difference is that you can travel on a travel document related to your TPS status, come back to the United States, and now you are in legal status for the purposes of adjustment based on employment. Asylum doesn't help with that. Only TPS does. Planning. Talk to an attorney, see if planning for your immigration future can be done through employment route, all right? And how to go about your managing your asylum case and TPS case together. Consult with your attorney if you have one. Consult with any attorney if you don't have yours. I believe it's worth the investment because, frankly speaking, immigration status is very important, right? You live in the United States, you want to have that freedom of travel, freedom of being free from worries as to what's going to happen to me, you know? Will I be able to see my family if they need me? Will I be able to ever sponsor my family members and so on and so forth, or find a better job? Some of you are stuck in these low-paying jobs because of your status, and you know you can achieve much more, right? And qualify maybe for those government grants and so on and so forth. So plan ahead. When you have TPS and asylum, at least you have something to choose from. And I'm very excited for you because usually if you have TPS, these days, you will be able to get the green card, at least through employment at DV Lottery. Well, guys, thank you very much for watching. I do appreciate all of your time, liking, sharing the streams, participating, asking questions, your gifts, hearts, stars. Really, really a big honor for me that you are such active, such loyal followers and subscribers. Remember, we're going to see each other again, hopefully, this Friday. As my Muslim friends say, inshallah, I'm going to be here this Friday, right? Because we never know. God determines our plans, but hopefully I'm going to be here. And if I didn't answer your questions today, I apologize. I will do my best to keep up with them next time. Thank you very much for liking, sharing, subscribing, and I hope to see you soon.